And welcome to the first Sustainable Global Economic Law lecture of 2023. It is truly my pleasure to introduce and welcome Professor Seline Trevisanut. She's professor at Utrecht University and has held the chair of international law and sustainability since 2018. So I'm not going to go over Celine's impressive transnational background that straddles various jurisdictions and features exciting projects. But I'll mention two things why I think she's the fantastic speaker for this SGEL lecture series. So her recent work focuses on ocean governance and sits at the intersection of international law, international environmental law and policy, and look at the interactions between different legal regimes and conventional and unconventional lawmaking processes. And second, she is the co-creator of a new and exciting and interdisciplinary LLM program on law and sustainability in Europe. And I hope that we will have time to talk about her experience during the discussion. Today, she will present her recent paper, The Future of Oceans, the Role of Human Rights Law and International Environmental Law in Shaping the Law of the Sea. Seline, thank you so much for joining us, and the floor is yours.
Thank you, Amanda, for such a kind introduction and for inviting me. Thank you, SGEL, for having me for this first lecture of 2023. It's really my pleasure. And thank you all for coming and to, let me introduce indeed one of my recent papers, but more broadly, actually, my research of the last years. And then, indeed, during the Q&A session, if you want, we can also talk about the new LLM program in Utrecht and how we have set up that interdisciplinary master in law and sustainability. But first of all, the topic of today. So I circulated a paper which is going to be published soon in a collected volume. And today I'm not going to go through all the arguments which are presented on the paper that you can read or not read, as you please. But I will just introduce you some of the arguments that I present there, and I will present them a bit in their broader context and how they relate also to other trends of my research. And then I will build on some of the conclusions that I reach in that paper and hopefully raise some more questions for future research also. So, my field of expertise and of origin is the law of the sea, as you might have gathered, also by the title of this presentation. And what I've been looking at over the years is indeed how actually different activities and different phenomenon are impacting the oceans, and why am I looking at the interaction between the law of the sea and the environment, then with the law of the sea and human rights, and then the triangle between the three fields, is that mainly our activities as humans are the ones which are having an impact on the environment, but also the human presence at sea is increasing. And so also issues of protection of the human element have emerged over the last decades and are now debated within the law of the sea. Here, just a little introduction on what is the state of affair in both fields, if you want, in the both subfields, environmental law and environmental protection and human rights protection. Here, just few images to give you not such a happy picture of what is happening. As I said, the marine environment is a very complex environment, which already within the oceans actually counts for many processes, ecological processes. And we know actually very little about the oceans. We know more to a certain extent about outer space than about the oceans, because actually funding and scientific research for many decades have been focused more on the outer space than on the ocean. So many of the processes and many of the ecosystems and how they work, in particular in the deep ocean, we still don't know exactly how they function. So we do not have really a complete and clear picture of the impact of the different human activities at sea. But what we know is that the ocean is the marine ecosystem. If we take a sort of, if we zoom out on the oceans, is the sum of different activities and processes, and it includes, of course, the water column, but also the seabed and the subsoil, and also the interaction between the coast and the ocean. And you can imagine that when we take that sort of large, broad picture, then we have many different actors, many different activities, and many different interests which come into play. We'll give you also an idea of what are the main sources of pollution. I have the graph on the small cake with the proportions of impact on the oceans. I'm sure you're all familiar about the issue of plastic that has been quite debated in the last years, plastic pollution at sea. Actually, plastic pollution at sea is part of land-based pollution, and it is indeed the biggest chunk of pollution coming into the oceans. It accounts for 44% of the total weight of pollution. The actual marine activities, so activities which happens only at sea, are actually responsible for the least of the pollution at sea. And this includes navigation, which has, of course, greenhouse gas emission, and also operational and accidental oil spills, seabed activities, so which includes oil and gas exploration, but also mining, and then other type of ocean dumping of wastes and processes of incineration. So those activities which happen only in the marine environment actually are responsible for more or less 25% of the overall pollution. All the other pollution actually comes from activities on land. As I said, because of the increase of the activities at sea and the impact actually also of the activities at sea, the human presence has become more and more evident, not only for the pollution, but also, unfortunately, for human rights violations. So we have, of course, the fishing industry is the main example. We have many vessels out there with crews, and we have had many reports over the years that some of the labor conditions actually can be construed as new forms of slavery in the fishing industry. But we have also issues linked to search and rescue operations. We are in Europe quite familiar with those issues because of the Mediterranean, but it's not only an issue, a Mediterranean issue. The fact that search and rescue services and operations are performed all over the world and that are challenged by migratory flows is actually an old issue of international law, and we still have many problems also in other areas of the world. So the human presence at sea has, on the one hand, increased the impact, the anthropogenic impact on the environment, but it has also raised a series of issues on how to protect the human when it is at sea. And also, of course, more humans you have at sea, more enforcement activities you have. So also the protection of the human is also discussed in what can the state do against humans which are behaving in a way which is contrary to some of the rules. So you have different aspects on how the human rights come into play and some safeguards come into play for the humans at sea. Now, the law of the sea and the governance of the oceans was not really designed for the human presence in a way, which is absurd because, of course, it was designed to regulate human activities and, in particular, economic activities, but not so much for actually creating safeguards for the humans which are performing those activities. This is a diagram which is useful to actually have a bit of an idea of what are the institutions and what are the instruments which are part of the Law of the Sea. We tend to think that the Law of the Sea is only the Law of the Sea Convention, the UN Convention on the Law of the Sea, which I'm going to mention a few times in this presentation, the UNCLOS, which was adopted in '82 and which is considered the constitution of the oceans. Many of you have heard of that expression in the past. UNCLOS is actually only one part of the puzzle. It is indeed the Framework Convention. It is the reference for most activities. It is in particular the reference for jurisdictional issues, both prescriptive and an enforcement jurisdiction. But it is, as I said, just a piece of the puzzle. For all the maritime activities, we have actually a plethora of organizations which are involved and many, many instruments which come into play, either to protect a specific species or ecosystem, either to regulate a specific activity, economic activity, so sectoral regulation, or to actually bring in different types of interests. So if we look at this diagram, which is actually the most commonly used, we see that already there we have the environment, which is nicely integrated within the ocean governance. Why? Well, because UNCLOS was adopted in '82, which was already a period of international environmental law lawmaking. So we have '72, we have the Stockholm Declaration, the Stockholm Conference and the Stockholm Declaration. And from there, we have, of course, more and more attention for the environment. We have a few treaties which are adopted in that period, but also because it was clear since the very beginning that in order to also guarantee the sustainable, economically sustainable use of the oceans, we need to have to set some limits to the exploitation of the resources. So you have already within UNCLOS the environmental part. In particular, it's part 12 of the Law of the Sea Convention. And we have within the Law of the Sea Convention a series of linkages which are created with international organizations such as the FAO, which is in particularly competent for fisheries, the IMO, the International Maritime Organization, which is competent for the safety of navigation and pollution from navigation in particular, and then with a series of conventions which have been developed over the years, like I'm sure you might be familiar with the CBD, the Convention on Biological Diversity, or the Convention on Migratory Species. Where are the human rights in all that? In this nice picture, which seems quite complete, but it's not. Where is the human element? Where is the protection of the people who find themselves at sea for many different reasons? Well, actually, the only one which is mentioned here is, or two, like one is the SOLAS, the Safety of Life at Sea Convention, which is one of the oldest instruments. It's actually the latest version of a very old treaty which was adopted after the sinking of the Titanic. And the idea was to create a system of cooperation in case of incidents and have common rules in case of collisions. So to create like also common standards on the type of equipment that you are supposed to have on board and so on and so forth. And then the ILO, so the International Labour Organization, where there have been attempts to regulate some of the maritime activities, in particular seafarers and fishermen. We have a convention on seafarers. We have a convention also on fishermen, which has never entered into force. So the part on labor laws, labor rights, unfortunately, still very weak within this framework. But that's it. That's the only human element that we have within this broader governance. We in particular do not have, and that's the common approach, other UN agencies which are, however, included in an interagency collaboration mechanism, which is called the UN Oceans. And within the UN Oceans, actually, it gives us a bit of a clearer picture of all the issues which are included in ocean governance and in ocean affairs. And here we find, for instance, the UNHCR. So in the previous one, the UNHCR is not included because it's not one of those agencies which is traditionally linked to the legal framework of the law of the sea. But within the UN, and because of the work that the UNHCR has done, it is included in the UN Oceans dialogue. And I will, in a moment, explain why the role of the UNHCR has been so important. So as you go through also all those nice acronyms, you see how diverse the topics which are included in ocean governance are, and also different legal frameworks are triggered by the maritime activities, and very different interests and also ways of thinking and reasoning about the law, actually, because if we think about the CBD and other environmental instruments, they might not have the same approach than the World Bank or even UNITAR on similar issues when we think about the protection of the environment. So on the basis of this sketched picture, what I've tried to do in that paper, and it's one of my sessions a bit in research, also Ivana mentioned how I'm always about how these legal frameworks interact. That's something that always triggers my attention. So on the basis of that a bit scattered picture that I just showed you, I wanted to analyze how, well, the law of the sea in particular, which is the legal framework, the reference legal framework, is interacting with all these different legal frameworks. And here I want to, I take as law of the sea a very broad approach to the law of the sea, which is not only the law of the sea convention, but all the instruments which are regulating maritime affairs directly. And in particular, what does that mean for the law of the sea, this kind of interaction? Because indeed, if we look at the law of the sea, which is a very old field of international law, if not one of the oldest, and it brings with it some very traditional and also conservative concepts and approaches to the law of the sea. It's very state-centered. It's very much linked to sovereign powers and the exercise of jurisdiction, territoriality. So it has some weight in a way which comes from this very long history of the law of the sea. But it has a framework convention. But on the other hand, it doesn't have an institution in charge. So the Law of the Sea Convention did not create an international organization, and it even doesn't have a conference of the parties. It even doesn't have a secretariat. The Law of the Sea Convention. Actually, there is a division of the UN Secretariat, which works as secretariat for the Law of the Sea Convention. So it is a framework convention, but without really an institutional framework that should guide, in a way, the implementation of this convention. But it has a compulsory dispute settlement mechanism. You might think, what were the drafters thinking? They went a bit, different ways. It's like we create the law of the sea, a framework convention, but no institution. But yes, the tribunal and the compulsory dispute settlement mechanism, no secretariat, which is usually the basic to have a permanent secretariat for a convention. But that's what we have in the law of the sea. that framework interacts, as I said, and with different fields of law. And there are other fields of law that interact with the law of the sea, but for the sake of time and also for the sake of the paper that I brought, I had to concentrate on some of them and on specific case studies. So there is, of course, international environmental law, which has its own narratives. It has a more recent branch of international law, which is still very much anthropocentric. So, of course, environmental law was created to regulate human activities and their impact on the environment. There are very nice approaches and pushes in the last years to have a more ecocentric environmental law, but it's a long process. What we have is mainly anthropocentric still. It doesn't have a framework convention. We have a plethora of conventions regulating different issues, protecting different habitats, species, and so on. And we have there a plethora of institutions and bureaucracies. Every convention has its own secretariat. They often have conference of the parties or meeting of the parties who can even adopt binding decisions. But we do not have tribunals. We do not have compulsory dispute settlement. And on the other side, we have human rights law, and I include, and we can discuss, so I include the refugee law in it, or at least part of it, because of the role of the specific role of the UNHCR had over the years, which is of course anthropocentric because of the nature of this field of law, which has different conventions. Some of them with very strong institutions, some of them with even courts and tribunals. So it's not only that the substantive rules interact in the regulation of the different activities and issues that emerge at sea, but it's also the different institutions and different dispute settlement mechanism which interact, creating sometimes some friction or at least ambiguities. And also the fact that these two fields of law are different, not only in the substance, but also in the same institutional setting, has had an impact on the law of the sea in the sense that they have institutions which have actually complemented some of the rules of the law of the sea, where there were no institutions in the law of the sea that could do it. So there is, yes, sometimes conflict, but also complementarity. Then maybe some more, then we can discuss whether this is the right direction for the legal framework. But indeed, the fact that those other fields have strong institutions has had as a result that those institutions took initiatives and complemented the legal framework where there were gaps in the absence of an institution from the other side. So what happened specifically with the UNHCR? I focus on the UNHCR because actually it is the first non-maritime organization which directly dealt with law of the sea issues in collaboration with maritime organizations. And actually it directly impacted the way in which we define the legal content of the duty to render assistance today. So the duty to render assistance at sea is a very old maritime usage. If you go back, you even find mentions of the duty to render assistance from 2000 years ago. And so from the moment in which humans have started to navigate and cross the oceans, this usage has developed. Originally, it was, and it still is, connected to issues of collisions or in accidents. Accidents which can include the breaking down of the navigation equipment, for instance. So then you get lost at sea. This triggers also the duty to render assistance. As I mentioned, the SOLAS Convention is the last version of a very old convention which was adopted after the sinking of the Titanic. Since then, we have had many instruments which have developed over the years, in particular in the field of collisions and accidents. And then in the 1970s, we have the so-called Indo-Chinese crisis, which is also the crisis which gave us the term boat people. So a large part of the population from Vietnam and from Cambodia, because there was the Khmer Revolution ongoing in Cambodia and there was the Vietnam War in Vietnam, were trying to flee their countries, and many of them took the sea. The problem that, well, we know very well nowadays too, is that many of the neighboring countries refused to disembark, refused to give access to the boat peoples in their ports, and then refused, or if they gave access to the ports, refused disembarkation. And also because of that problem, more and more private vessels, which have an obligation to render assistance, were actually trying to avoid the people in distress in order not to find themselves stuck with the people on board and nowhere to go, which is a problem that we still have today. On the basis, so that was the context in which the 1974 Safety of Life at Sea SOLAS Convention was adopted. So that convention in particular sets a series of requirements for equipment which vessels have to have on board. Merchant vessels, private vessels. I'm not talking about state vessels. And then in 1979, right at the peak actually of the Indo-Chinese crisis, we have the adoption in Hamburg of the Convention on Marine Search and Rescue. I will show you in a moment how the UNHCR actually was key for the adoption of that convention and also for defining some of the obligations in it. And the UNHCR was also key in shaping the amendments to both convention in 2004 and in developing, in collaboration with the International Maritime Organization and the International Chamber of Shipping, rescue at sea guidelines, which are the ones which are applicable still to merchant vessels. So the UNHCR, the UNHCR was involved since the very beginning of the Indo-Chinese crisis because most of the people fleeing were actually refugees and which were fleeing from a war zone. And the role of the UNHCR was key in particular because it gave content to what rendered assistance means. Here, this is the Article 98 of the Law of the Sea Convention, which is currently applicable and which is considered customary international law. And you can see I highlighted in red the main actors involved in this duty to render assistance. The states, not any state, but the flag state, the state of nationality of the vessel, the master of the ship, which is the authority on board, which is supposed to enforce that obligation, and then this duty to render assistance to whom? To any person found at sea in danger of being lost, or persons in distress. Distress means that there was a distress call. Okay, person found at sea, it's a person in danger, even if there was no distress call for X reasons. It doesn't matter the reason why there was no distress call in order for this obligation to be triggered. The issue was, what does it mean to render assistance? There are many different measures, activities, which can actually, you have quite a wide spectrum of activities that can be performed in order to render assistance, from just giving water bottles and food, and that's it, to actually also just to launch, to forward the distress call you receive. That's also it can be part of the chain to render assistance, to actually taking them on board or bringing them to a port of safety. The main issue was, well, what happens once there was contact between the vessels, and what happens, well, once the merchant vessel, because again, here we are talking about private vessels, have taken the people on board. And there, the UNHCR was key in designing, actually, in starting the debate and in pushing states to deal with the issue of disembarkation already in the 70s. So in 1979 and in 1985, through the coordination of the UNHCR, two programs, DISERO and RASRO, were adopted in order to force and coordinate actually the disembarkation and resettlement of both people from Indochina. In 2004, as I said, there were amendments to both the SOLA and the SAR convention. And for the first time, the concept of place of safety was actually integrated in the legal framework. So to render assistance means not only to save, actually intervene at sea, but it includes also the delivery of the people rescued in a place of safety. That concept is within the legal framework now. What place of safety means, there are a lot of discussions still. But we managed to have it in the legal framework. We didn't have it until 2004. Thanks to the UNHCR also, and the work done during the Indo-Chinese crisis, but also during the 2004 amendment, we have had a discussion about the protection of the refugees and of migrants at large during search and rescue operations and enforcement operations, actually, more broadly. Already in 1981, within the Indo-Chinese crisis, the Executive Committee of the UNHCR adopted a decision which said very clearly the principle of non-refoulement applies at sea, even at those saved at sea. Thanks to that decision, which was contested, debated by states, but not in the Indo-Chinese crisis, actually, many of the states of the region did not contest it. They just said that their justification was, we do not have the means to comply, but they did not contest the existence and the applicability of the norm. Very different from the American approach, the US approach in the 90s, in another migrant crisis with the Haitian crisis. In that case, actually, the US position was the principle of non-refoulement does not apply at sea, full stop. It only applies once the people have reached the land. And this is the so-called dry foot, wet foot policy that is still in the handbooks of the Coast Guard. So in that decision, on the basis of that decision, the UNHCR started quite an intense collaboration with the IMO, the International Maritime Organization. Why the IMO? Because the IMO is the international organization in charge of the safety of navigation. And it is the organization which organizes also the secretariat of many of the conventions applicable, including the SOLAS and the SAR, but also including other conventions, more technical conventions on type of equipment, for vessels which transport dangerous goods and so on and so forth. So that's the reference, the IMO. And that's why the UNHCR and the IMO started to collaborate. And it is thanks to that collaboration that we now know clearly that the principle of non-refoulement applies at sea, and that has been confirmed afterwards by the European Court of Human Rights in 2012 in the IRSI case. It has been confirmed also by the Human Rights Committee in a more recent case in 2021 against. The principle of non-refoulement is not only applicable, of course, for migrants and for refugees, but for all of us. And it's an important principle because, well, if you are saved in the middle of the sea, you wish to be brought to a place of safety and not to any random place. So it's a good principle for all of us. Then, on the basis of the work of the UNHCR, also there was a gradual recognition that refugees in particular had to be protected in the sense that their right to seek asylum had to be protected from the moment in which they were saved at sea. And then more broadly, thanks to that cooperation, we have the human rights approach to search and rescue operation, which did not exist before. So all the debate about human rights was started by the UNHCR, actually. And now it is in front of the European Court of Human Rights, it is in front of the UN committee and so on. But it all started because of the involvement of the UNHCR. So yes, the first debates about human rights at sea have been within search and rescue operations. Now it was seen as an intersystemic dialogue, so how the sea should interact with human rights. It has slowly become actually an intra-regime issue. More and more issues of human rights are seen actually as law of the sea issues, also by the compulsory dispute settlement mechanisms of the law of the sea. So we have consideration of humanities, which were discussed by ITLOS in the framework of enforcement operations. We have the Arctic Sunrise case by an arbitrary tribunal created on the basis of the Law of the Sea Convention, which recognized the application of human rights at sea. And then lately, you might have heard of this request for advisory opinion about climate change, which is an environmental law, mainly an environmental law, request for advisory opinion in front of ITLOS, but there are many commentators pushing in a way ITLOS to also include a human rights approach to climate change in answering that request for advisory opinion, in particular when assessing the adverse effects of climate change on the oceans. And so to also include the social dimension of climate change. We'll see what ITLOS will do. Let me now briefly go into the other part, a completely different topic. The offshore energy sector might seem a bit dry as a topic compared to the UNHCR and search and rescue operation, but I can assure you there are a lot of interesting things happening also in the offshore energy sector. And it is interesting to compare how the two interactions have happened, because we have completely different settings. So there we had the initiative and the pull factor, which was the UNHCR. Here it's completely different. So the offshore energy sector is one of the sources of pollution at sea. Not only the oil and gas, but actually also renewable energy structures and technologies are part of pollution. They also pollute. So they are actually raising a series of issues. But it does not have a centralized framework. So we do not have a framework convention on oil and gas exploration, for instance, very differently than other fields like navigation, where we have some framework convention on oil spills and so on. But for oil and gas exploration, we do not have that. And it is very much industry-led in the sense that many of the standards that are applicable also at the international level actually come from professional associations which have developed codes of conduct and guidelines over the years in the absence of a legal framework. So it's a bit of a vicious circle, if you want, there, because we do not have the legal framework. We have the professional associations, and then they have to fill a gap. But then, as that is happening, there is no will from the state to develop a stringent legal. So it's a bit of a weird dynamic. So as we do not have a framework convention, and bear with me for the next 2-3 slides, where there are just lists of instruments, just to give you a bit of a picture of what happens in the offshore energy sector and what are all the instruments that need to be taken into account depending on the type of problem or issue you want to regulate. So the legal framework is highly scattered in this field. There is a fragmentation rationale materia, as we do not have a legal global treaty. So we have a series of relevant treaties. The Law of the Sea Convention, of course. Why? Because it is the jurisdictional framework. So it is the treaty which gives rights and obligations to the coastal states. But actually, the Law of the Sea Convention has almost nothing, very little on the regulation of the actual activities. There is a general obligation on prevention, reduction, and control of the pollution. And then we have this very important provision, Article 237, which opens up the Law of the Sea Convention and says, well, you need to apply the obligations of the convention in compliance, in conformity with other environmental law treaties you are a party of. And that opens up to all that, to all the treaties that are relevant for many different issues. So we have instruments which deal with the specific sources of pollution, and I'm not going to read you the titles there, but you see a bit the different issues which are regulated there. And then we have the global instrument tackling specific environmental areas or issues. So the Ramsar Convention, sorry, I should have written it. I should have wrote it. It's about wetlands. Wetlands are mainly on the coastal areas, but they also apply on certain maritime areas just off the coasts. The World Heritage Convention, it's not an environmental convention, but you can actually have natural sites listed in the World Heritage Convention list, and then it applies to the protection of the environment, the ESPO Convention on Impact Assessment, the Convention on Biological Diversity. And that's just the global treaties. Because then you have the regional ones. The regional ones, which are also triggered by the Law of the Sea Convention, you have another little window created by Article 208, paragraph 5 of the Law of the Sea Convention, which says that the states should establish regional rules. So they are triggered by the legal framework, but at the moment we only have 4 regional systems which have specific rules for oil and gas exploration for offshore energy protection. So the OSPAR for the Northeast Atlantic, the Helsinki Convention for the Baltic, the Barcelona Convention for the Mediterranean, and the Kuwait Convention for the Gulf. So this is the patchwork, this is the puzzle that you have to put together depending on the geographical area that you are looking at, where the problems are arising, and the type of problem that you want to deal with. And then we have the institutional fragmentation. The IMO, which I mentioned many times earlier, and which is in a way the common thread between the two topics, actually does not have a clear mandate for offshore energy production. It has a mandate for navigation. That's its main function. But then over the years, through not formal amendment, but through authoritative interpretation of its own mandate by the Secretariat often, it said, well, actually pollution directly arising from exploration and exploitation, well, it's not directly within the mandate, but it is still of concern, and we can contribute to the establishment of international regulations. And that's what they did over the years. So we have the guidelines for the removal of offshore installations, and we have all the system about dumping, which is to leave waste at sea, to dump waste at sea, voluntarily, not as part of an accident, but voluntarily. So the IMO has a bit filled in a gap, as we do not have an institution, but it does not have a clear mandate. And actually there are many states, in particular from Southeast Asia, which are contesting the role of the IMO, saying that the IMO actually is having a too Western approach to some environmental issues, and which does not take into account the capabilities of the states in other areas of the world, in particular from Southeast Asia. To that, we have the IMO, which has this kind of global mandate, and then we have the different organization bureaucracies linked to the different environmental treaties which are triggered by the field. And what I tried to do in the paper, and I'm going to mention it very briefly now, is like to just take one issue and see a bit how they kind of interacted with each other in relation to the obligation of environmental impact assessment. The obligation of environmental impact assessment is the basic obligation which we have in the Law of the Sea Convention and which is part of the different legal frameworks that I have mentioned. In particular, the Convention on Biological Diversity, when it was adopted, was the first one, almost the second one, sorry. Well, one of the first ones with a strong conference of the parties, which could adopt also binding decisions. And it adopted some guidelines for the biodiversity inclusive impact assessment. Those guidelines were then mentioned and referred and integrated by the Ramsar Convention through a decision of the Secretariat. The same guidelines were also, not 22, resolution of the migratory species. There is a mistake, it's 2012, because otherwise it doesn't work chronologically. Oh.
Yeah, you didn't find it okay.
I didn't touch, yeah, sorry. I was for too long on this slide. So it's 2012, the decision of the CMS. So there is a sort of cross-fertilization, if you want, between the different bureaucracies of this convention. So first the CBD adopts the guidelines, and then they are kind of taken as reference by the other treaty bodies. And they integrate then the legal framework of these other conventions. The same when it comes to strategic environmental assessment, which is a broader assessment than environmental impact assessment, which takes into account also the social dimension, the social impact of an activity, which was first created under the ESPO Convention with a specific protocol, and which then was referenced again and again by the UN Guiding Principles on Business and Human Rights, and also by the OECD guidelines on multinational enterprises. So you have all these kind of different bodies with very different mandates, of course, which kind of reference each other and slowly kind of create some content on those norms. Because then when we look at what the Barcelona Convention did in one of its most recent lawmaking moments, so the meeting of the parties of the Barcelona Convention for the Mediterranean adopted in 2019 the offshore guidelines and standards, which are actually binding for the member states party to the offshore protocol. So it's not just a recommendation, but those are binding by guidelines. And even there, you see how the meeting of the parties actually refers to the OSPAR Convention, and then to what the World Bank has done, and then what also the International Association of Oil and Gas Producers. Here we have a professional association. So in this sector, where we do not have a centralized authority, where we do not have one international organization which is competent, which is different for fishing, for instance. Fishing, FAO. Navigation, IMO. Offshore energy, I don't know. So it goes a bit in all directions. So when also the regional instruments have to develop and continue to update their own instruments, they look at all these different institutions and conventions and so on, which on the one hand, it allows these legal frameworks to update each other and to communicate, which can be positive indeed. Maybe instead of being a race to the bottom, they might actually stimulate each other towards higher standards. But on the other hand, there is actually some difficulties in understanding where the legal framework is going and when also the developments are happening. There are not clear steps. So some concluding remarks. So it is clear from both examples that we have a polycentricity of lawmaking processes in the law of the sea. the law is developed, discussed, debated, sometimes implemented in many different institutions and with very different approaches. On the one hand, this allows the legal framework to keep updated with what happens outside the law of the sea. So the law of the sea, far from being a closed system, is actually a quite open one. Also, the law of the sea convention, first of all, has all these windows, these conventional bridges, which allow these other legal frameworks to be triggered in the application of the law of the sea convention. But at the same time, then as we do not have a strong central institutional framework, there is no real coherence, let's say, or not even coherence, but it's not always easy to have a clear picture of what are the interests which are represented also by these other institutions and these other instruments which are triggered in. And also, again, where is the path? Like towards which objectives are we moving? If it is clear that when the interaction is between the law of the sea and the CBD, or the law of the sea and the UNFCCC, you know a bit where this is going to a certain extent. But even in the interaction, it will depend what are the interests which have the higher which have the priority, and that will depend on the bureaucracy or institutions which is looking at it. And that creates, again, a very scattered picture. So it's not such a happy picture for the future of the oceans, if I may, but there are some mechanisms and some bits here and there, I hope, that can create some optimism sometimes. I hope. I still have some optimism. Not much, but a bit. Thank you.